I'm Hetal Sanghvi and I'm a tax partner at Edwin Co here in Lincoln's Inn. I have a mixed practice consisting of tax compliance work, tax dispute work, which consists primarily of inquiry work and also regularisation, which is voluntary disclosure work. But also a very large part of my practice is tax advisory work. And that's really focused on advising high net worth families looking at succession, entrepreneurs who might have liquidity events, globally mobile executives, potentially thinking about relocation to the UK and events, life events like that. In terms of our offering, it's a bit unique in the sense that we have that compliance and dispute background, which informs the way in which we advise clients. Today, I thought it'd be interesting to talk about domicile. It's a highly political topic at the moment in the context of our Prime Minister's wife, who has been in the newspapers, and her domicile status has been of interest when we think about it from a media perspective. But domicile is something that affects a lot of clients, and a lot of the economics actually presents a different picture to what we might see in context in a political sense. So I thought it would be interesting to think about those clients that we advise who do rely on their non-domicile status in the UK and some of the challenges that they're currently facing. The concept of domicile is a common law concept which identifies where an individual's permanent home is, and that's initially based on a father's domicile at the time of an individual's birth. And this domicile of origin is very adhesive. Typically, it's only displaced by a domicile of dependency, which is less common, or a domicile of choice in a new jurisdiction, and this requires both actual residence in a new country and an intention to reside there permanently or indefinitely. Now, a lot of our clients rely on their domicile status for the basis of their exposure to taxation in the UK, and often there is a visibility perspective from HMRC's side, be it from an inheritance tax perspective, be it a claim for the remittance basis of taxation, or relying on something like the motive defence for the treatment of a tax structure that they might be involved in. So there are a number of trigger points where HMRC may seek to challenge an individual's domicile. Now, historically, a lot of the challenges that we saw were at the time of death, i.e. HMRC would seek to argue that actually an individual had acquired a domicile of choice in the UK if they passed away in the UK or only left the UK shortly before their death, having resided in the UK for many years. We have, though, through many years of dealing with domicile challenges, come across a number of specific areas which either have been points that HMRC have attacked or points that we as advisors have identified as areas that could be considered further, particularly in the context of case law. One of these points is residence, and particularly residence in the context of domicile. Now, residence for the purposes of domicile does not have a statutory definition, but if we look back to case law, we see references to the term an inhabitant. Now, one key difference that came across to me when thinking about residence is that for the purposes of domicile, one considers intention, and that is in line with our historic concept of ordinary residence, which many years ago was used to think about residence from a statutory residence perspective. Now, it doesn't have a space in our statutory residence test, so you could, in theory, have an instance where an individual is not tax resident in the UK and has only been in the UK for a short period of time, but HMRC may challenge that they have triggered residence for the purposes of domicile due to their intention. Another linked difference is to do with immigration. I've often come across scenarios where an individual arrives in the UK on a tourist visa, but unknowingly triggers a tax residency based on the sufficient ties test within the statutory residence test. Now, residence for domicile identifies that if an individual comes as a tourist or on a short-term business visa, they lack the necessary intention and therefore are not considered resident for the purposes of domicile. Another topic that we've seen HMRC take the point around is chief residence, and that's applicable where an individual is considered, specifically for the purposes of domicile, resident in two jurisdictions. Now, I recently looked after a long-standing inquiry into the domicile of a deceased individual whose estate administration we were also looking after, and we were more than 200 questions into considering residence and the pattern of living in both the UK and Italy, and we landed on the multifactorial test of where this individual's chief residence was. Barlow Close International v Henwood asserts that when ascertaining chief residence, one should not simply consider the main home. It's not about the size or amenities, nor the home in which an individual spends the most amount of time, but rather one should look at the quality of residence. Now, HMRC sought to assert that because the value of the home in the UK was substantially more than the value of the home in Italy, that the UK was this individual's chief residence. And that's where we reference exactly Barlow Close v Henwood to argue that it's not the value of the property, because surely that could be completely misleading depending on the property prices in that jurisdiction and currency values, but rather the quality of a residence. HMRC further raised the point that total asset values were greater in the UK in comparison to Italy. And similarly, one could argue that that's a commercial decision based on investment diversification. Now, the reason why this case was of particular interest is that the UK maintains an old estate duty treaty with Italy, and therefore, where we were successful on the domicile point, the deceased's non-UK assets, so her Italian assets and those that were financial portfolios outside of the UK, those would be outside of her estate when it came to inheritance tax. So needless to say, it was really crucial that we did try and win this, and we were successful in settling this inquiry with HMRC, and we came away with some practical recommendations, which I will talk about in a little bit. The last point that I want to talk about is defined contingency, and this is where HMRC consider whether an individual has acquired a domicile of choice in the UK. They typically consider whether the individual has sufficient intention to leave the UK. Now, for many years, the leading case here has been IRC v Bullock, where the taxpayer was not treated as having acquired a domicile of choice on the basis he had a reasonably anticipated contingency upon which he would have left the UK. Now, what is clear from case law is what is not considered a defined contingency. So, for instance, if I make a fortune or when I've had enough of it. In practice, we often see individuals identify that their defined contingency will be that they'll leave the UK on retirement. Now, there was a real shake-up on this quite recently in the Henkes v HMRC case, and the points that were taken into consideration were things like his age, he was 76 years old, he had no current plans to retire, his intention to retire was seen to be no more than a vague aspiration, no significant links to the domicile of origin country, and his home in Spain was deemed to be more akin to a holiday home. In comparison, the links to the UK were strong. More than 50 years of residence, children, grandchildren resident here, wife was settled here. So this was an in-life challenge as opposed to at the time of death, and HMRC won the case that he had acquired a domicile of choice in the UK on the basis that it was a combination that the defined contingency was not seen to be strong enough, and in comparison he retained significant ties to the UK. I'd also recommend having a domicile statement, perhaps in the country where an individual believes themselves to be domiciled. So this can be supported by an opinion written in line with the law of that foreign jurisdiction. Now, where this is critical is if an individual is relying on that domicile position for any tax planning, and that could be governed by a treaty that may assert that the country in which you are domiciled or consider yourself to be domiciled must accept you to be domiciled there. So coming back to the earlier estate case I mentioned, a crucial turning point in that inquiry was us obtaining an Italian law opinion with regards to the deceased's domicile. This is typically, of course, far more challenging retrospectively, so where possible we do recommend that that's obtained in an individual's lifetime. It would also be useful to consider if an opinion should be obtained for any other individuals upon whose domicile one is reliant. So previously, I've had a case where an individual was born in a country that differed to her father's domicile at the time of her birth, and therefore it was really useful in that case to actually identify and obtain a domicile opinion for her father. Now, this would then be relied upon when asked about her domicile of origin as a starting point from a HMRC perspective. It's also important to think about if an individual has a home in the country where they believe themselves to be domiciled. And if that is the case, then really thinking about the hallmarks of what might look like a holiday home versus a home that one is preparing for relocation to that home. So things like storage of personal possessions, bank accounts, etc. And the last point I'd like to touch on is naturalisation and applying for citizenship. Now, naturalisation has always been distinct from domicile. However, there has recently been changes in 2019 on this matter, so what we would recommend is seeking specialist advice and applying some caution before thinking about naturalisation in the context of domicile. So here in the tax team, we've dealt with a lot of domicile inquiries, and what that means is that we can assist if you or your clients face such challenges from HMRC. But the other angle is actually this really informs and drives the way in which we advise clients. So if you are looking at relying on your domicile position, then I would strongly recommend that you do seek advice with regards to your domicile position, and that's an area that we have a lot of experience in. Likewise, in terms of the tax team and its wider offering, as I say, there's a unique position here because we have our dispute and compliance background, which really assists the way in which we proactively advise clients. And this is further enhanced by the fact that we can implement that advice by working closely with our colleagues in and around the rest of the firm, be it our private client colleagues, our immigration team, corporate, residential property, or employment teams. These tend to be the teams that we work with very closely, and I think that's what hopefully makes our offering quite unique.